Good day. My name is Nancy Tan Kylie. In today's presentation, I will critically analyze ChatGPT responses, evaluating their accuracies, biases, knowledge gap, and alternative perspectives. This analysis will be supported by relevant legal provisions, case law, and academic insights. As AI-generated legal insights become more common, it's important to critically assess these responses and make sure they uphold under legal scrutiny. The first key aspect is accuracy, evaluating the factual correctness and reliability of information. ChatGPT provided an overview of the UK copyright framework regarding AI, mentioning fair dealing exceptions and licensing models. While mostly accurate, the response missed some important detail in UK copyright law, such as the difference between commercial and non-commercial text and data mining, which has the legal implication under the Copyright Design and Patent Act 1988. One of the main issues surrounding AI and copyright is the tension between intellectual property rights and technological advancements. Case law such as Infopa versus Danske highlights the importance of originality in copyright protections, which affect the AI training practices. AI-generated responses should reference such cases to improve reliability. The Infopa case ruling determined that even an 11-word excerpt from a copyright work could qualify for protection if it reflects the author's intellectual creations. This affects AI models that collect data for training purposes, as they might unknowingly use small but legally protected portion of text, leading to legal right issues. Furthermore, in Meltwater versus Newspaper Licensing Agency, the Supreme Court held that even temporary copies of copyright work, such as those created for online news monitoring, could constitute copyright infringements. This ruling demonstrates how AI models engaging in data scraping and machine learning must navigate strict legal boundaries. While ChatGPT gets the key principle right, but it could be better by adding specific case law to support its points. Second, potential biases, identifying limitation in AI output. Bias in AI responses often arise from training data limitation and inherent algorithmic biases. For instance, ChatGPT responses on the UK's AI copyright framework prioritize economic growth and innovations, reflecting a policy-oriented bias that may overlook copyright holders' moral rights under international treaties like the Berne Convention. This treaty, which the UK adhered to, established that copyright is not merely an economic right, but also a moral right that protects an author's connection to their work. The AI emphasis on expanding fair dealing exceptions align more with industry-driven interests rather than a balanced stakeholder approach. This is problematic because it suggests an implicit preference for AI developer over copyright holder. The bias become evident when analyzing judicial perspectives, such as in Meltwater case, where court upheld strict interpretation of copyright exceptions. This ruling contradicts AI-favorable policies that support expanding fair dealing provisions. Moreover, AI-generated responses reflect the influence of legislative narrative that favor technological progress. In cases like Author Guild versus Google Incorporation, the court ruled in favor of technological innovation over strict copyright enforcement, arguing that scanning book for indexing purpose constitute fair use. ChatGPT responses tend to reflect this perspective while failing to fully address the counter-argument from copyright holders who view such practices as unauthorized exploitation of their work. Third, knowledge gap, accessing incomplete or outdated information. ChatGPT responses sometimes demonstrate knowledge gaps, particularly in evolving legal areas. A key example is its discussion on regulatory oversight. where it suggests a dedicated UK regulatory body for AI transparency. However, it does not reference existing UK regulatory efforts, such as the UK Intellectual Property Office consultation on AI and copyright. One of the bigger missing points in ChatGPT responses is the failure to discuss Article 17 of the Digital Single Market Directive, which significantly impacts the AI interaction with copyright work. Although the UK is no longer bound by EU law post-Brexit, the directive provides valuable insights into how other jurisdictions are handling AI-related copyright issues. Article 17 places liability on online platforms for user-generated content, potentially setting a precedent for AI developers in terms of responsibility for training data. AI-generated content should incorporate this legal development to avoid presenting outdated information. Another example of the knowledge gap is the omission of Data Protection Act 2018 and its intersection with AI. This legislation governs personal data usage in AI training models. Without referencing it, ChatGPT response failed to address a critical aspect of AI regulations, which is the data privacy. The general data protection regulations also raise significant compliance challenges for AI companies, particularly regarding the lawful basis for processing data. ChatGPT responses should integrate this element to present a holistic legal analysis. Lastly, AI-generated content often presents dominant legal perspective while overlooking alternative viewpoints. For example, when discussing AI copyright framework, ChatGPT focuses on policy mechanisms like licensing and opt-in or out structures. However, it does not sufficiently explore ethical consideration or human rights implications, such as those raised under general data protection regulations concerning AI use of personal data in training models. An alternative perspective is the argument that AI-generated works themselves should be granted copyright protections. Currently, UK law does not recognize AI as an author, as stated in Copyright Design and Patent Act 1988, Section 9, which attributes authorship of computer-generated work to a person who made the necessary arrangement for the creation. However, scholars like Abel argue AI should be granted legal personhood to ensure accountability and fair compensation. ChatGPT does not address this emerging debate, indicating a gap in alternative perspective. Additionally, legal theorists have explored the concept of data dignity, which argue that individuals whose data contribute to AI training should be compensated. This perspective is notably absent in AI-generated discussion on copyright framework. Countries like Canada and Germany have proposed models where AI companies pay royalty to content creators when their work used for training. By failing to discuss such developments, ChatGPT presents an incomplete picture of global AI regulations. In conclusion, while ChatGPT provides valuable legal insights, its responses require critical analysis. Future AI legal research should incorporate case law, legislative update, and diverse perspectives for a more balanced analysis. To ensure reliability, users must apply independent reasoning, verify sources, and consider multiple legal viewpoints. As AI reshapes the legal field, ethical and regulatory framework must evolve to protect fundamental rights. Thank you for your attention.